Good morning, everyone. Today we'll be discussing the topic, a very key topic in law, known as what or called what negligence. 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 In the layman's language, negligence simply means failure to take proper care of something or someone. In law, it means the breach of the duty of care which results in damages or suffering to someone or something. In fact, negligence is a form of recklessness. Now, what is recklessness? Recklessness means lack of regard for the danger and consequences of one's actions. It simply means rashness, being rash, not caring about consequences. It is a dangerous behavior that a reasonable man will conclude from that you didn't care about the consequences of your actions. It could be financial recklessness, for instance, when someone gives you power of attorney over their property, over what they have, and you invested without what taking proper care. Or it could be criminal recklessness. So recklessness is a state of mind where a person deliberately and unjustifiably pursue a course of action while all the time consciously disregarding any form of danger flowing from such action. That is a reckless behavior. One, you know that there is possibility of danger, there is danger, but you disregard that danger nonetheless. Now let's move back to our topic of today, which is negligence. So negligence is the failure to behave with a level of care that a person of ordinary prudence would have exercised under the same circumstance. The situation usually consists of actions. That is what we do on day-to-day basis. Or sometimes it could also be an omission, especially when the law requires you to act in that regard. For instance, a duty to help victims of one's previous actions. Now, before we proceed proper into this discussion, there are a number of things we need to look into. Now, for a case of negligence to stand in court, there are certain things that must be considered. We're going to look at them one after the other. One of these is what we refer to as knowledge. Knowledge is very, very important in the charge of negligence. Now the perpetrator must have an idea or have the knowledge of the existing circumstance or circumstances. He must have an idea, he must have the knowledge that such a thing, there's such danger. For instance, in a case of, let's say, charge of possession of counterfeit money, for instance, the person who is being charged must be aware and know that what he has is counterfeit money. Knowledge is very, very key in the case of in cases of negligence in law. That is not to say that it is every time that knowledge can be inferred from the direct evidence or anything. Sometimes knowledge can also be inferred from the circumstances of the case. So one need to still exercise care. Another thing they consider is also what we refer to as accidents. There are certain things that are beyond the control of people. So if it can be proven that the accused or a reasonable man of his standing in the society could not have foreseen the occurrence of what happened, then that accused person escapes liability. The law will not hold him responsible for that action because it is an accident. Now, responsibility is also not attached to an action to an action committed unconsciously or in a state of mind known as what? Automatism. For example, sleepwalking. Someone who committed an act while that person was sleepwalking, that person will escape liability because it is an unconscious what act. Now let's move back to our study, which is negligence. In this study, we are going to divide negligence into two types or two forms. We have what we call civil negligence and criminal negligence. They are not the same. Okay. Sometimes the difference in these two is merely just matter of degree. And that is why in criminal negligence you hear things like gross negligence, grievous negligence, and all that. So it is a matter of degree, the matter of extent that distinguishes between civil negligence and criminal negligence sometimes. Now we'll start with civil negligence. It is also known as due diligence. Due diligence. And this is simply the failure to use reasonable care that a reasonable person would, resulting in damages to another person or resulting in injury. So civil negligence is an integral part of what personal injury cases because yes, because injury is always a result of someone else's negligence. Now, another area where civil negligence is different from criminal negligence is that civil negligence cases are handled in what? In handled in civil courts. This is another major what difference. Now, injury resulting from someone's negligence does not necessarily have to be filed by the person involved, especially in a situation where the person is what was incapacitated as a result of what the incident or the person was deceased. A family member can also what do that on the behalf of what such a person. Does not necessarily have to the person does not necessarily have to be the one to file such one charge. Another thing we need to know about civil negligence is that somebody who injures another person can what have a civil liability for that what action, even though his actions were what unintentional. Now, civil negligence can occur in cases in slip and fall cases, accidents in workplace, or even car accidents. One example, for instance, is one a doctor who operated on the wrong patient or who operated on the wrong part of the body simply because he did not read the chart very well could be charged for what? Civil negligence. A shop owner, for instance, who mopped the floor and refused and forgot or did not put up a wet floor sign could also be liable for what? For civil negligence. Especially when a customer comes in there and sleeps on the wet floor and injures him or herself. The shop owner will be what? Held liable in court. Now, a property owner who allowed the steps to his home to decay could be held liable if he invited friends over and they injured themselves as a result of the decay to the property. He could be held what? Liable for such what? Injury. But it also depends because in law we also have what we call what? Comparative negligence. Okay, because in this kind of situation, both the accused and the person accusing him are both negligent. So the judge will have to what to compare the level of negligence of what the two parties. Okay. Now, for instance, in the case of a man whose property decayed and invited friends over, and then in court, he has to establish the fact that if he can prove that the friends are aware or they have knowledge of the condition of the environment or the condition of the premises, who will not pay the full extent of the damage, or it depends on who was more negligent. Okay, if he is more negligent, he will pay, not full, but to the extent of his negligence. Now, but if it's the other party who is making the accusation is more negligent, then he will escape liability because if there is a tie in law, the tie favors the what? The accused. When there is a tie, 50-50 chances, 50-50 negligence, it favors what? The accused. So for the claimant to actually claim anything in law, he must at least would be less than 50% responsible for his action. He must at least be maybe 49. And the person accused must be at least 51% responsible for him to claim, only to claim. And in this instance, he's going to claim 51% of his original what? Demand. Now, now, in the case of the wet floor sign that I gave earlier, where a shop owner mopped the floor and refused to put up a wet floor sign, in that kind of instance, if, for instance, the person who came into the shop contributed to what happened, then it could also impact the judgment. For instance, if a slave queen or an Instagram model comes into the shop and decided to take pictures, decided to be reckless, to be careless, not caring much about his actions, then it could impact how that judgment will go. That is because the law requires you to take care of you, to take care of yourself before you look to others to take care of you. So the judge will consider this, and it's very, very what important in how the decision will what go. Another example that could result in civil negligence is in a situation whereby you know you have a dangerous dog as a dangerous dog that have had infractions or that have beaten people in the past, and you take it to park, and that dog bites a small child, then you could be sued for what? Civil negligence. But in some jurisdiction, in some crimes, for instance, there is what they call the one bite rule. If you have a dog, that dog must have beaten somebody before, and you know that the dog is dangerous before you can be liable for when the dog bites the next person. But not in all crimes, anyways. Okay. So we're going to end this video, this particular video. This is the part one of this because this video will be in three series on negligence. So the next time, the second video, we're going to look at important cases that borders on what? No, that is on the last one. But the second one we look at was civil criminal negligence. But today we are going to end the video here to avoid extending this video too far. Now, my name is Nwete Nelson Ikechukwu. Please subscribe to what? To my channel. Hit the notification bell so that you can get more fantastic videos like this. Please share this video. Okay, please like and subscribe. Thank you. See you soon.